Each one that it will be not correct to say that it is only the accused who must be fairly dealt with. That would be turning Nelson's eyes to the needs of the society at large and the victims or their family members and relatives. Each one has an inbuilt right to be dealt with fairly in a criminal trial. Torture in custody flouts the basic rights of the citizens, and is an affront to human dignity. It is said to be a blow at the rule of law. The SC held custodial violence to be a calculated assault on human dignity, perhaps one of the worst enemies in a civilized society governed by rule of law. Any form of torture or cruel, inhuman or degrading treatment would fall within the inhibition of Article 21, whether it occurred during investigation, interrogation, or otherwise. In view of the growing incidence of torture and death in police custody, the SC in Dilip K. Basu vs. State of WB 2003-12 S.C. C. 174 issued directions to the center and the state governments to prevent violation of human rights of accused persons as also the prisoners. The SC in VC. Mohan vs. UOI Air 2002 SC 1205 held that the draconian concept of law has had its departure quite some time back and rule of law is the order of the day. It is this rule of law which should prompt the law courts to act in a manner fair and reasonable, having due regard to the nature of the offences and vis liberty of the citizens. In this case, detention of the petitioner made under the COFEPOSA Act, 1974 without placing the relevant material before the detaining authority, by the sponsoring authority, within time prescribed was quashed by the SC as unlawful and illegal. 6. Rule of law and judicial scrutiny or review. It is a basic principle of the rule of law that the exercise of power by the executive or any other authority must not only be conditioned by the Constitution but must also be in accordance with law, and the power of judicial review is conferred by the Constitution with a view to ensuring that the law is observed and there is compliance with the requirement of law on the part of the executive and other authorities. In P. Samamurthy vs. State of AP, Air 1987 SC 663, the SC observed, it is through the power of judicial review conferred on an independent institutional authority such as the High Court that the rule of law is maintained and every organ of the state is kept within the limits of the law. If the exercise of the power of judicial review can be set at naught by the state government by overriding the decision given against it, it would sound the death knell to the rule of law. The rule of law would be meaningless as it would be open to the state government to defy the law and yet to get away with it. The SC in Re. Arundhati Roy, Air 2002 SC 1375 observed, rule of law is the basic rule of governance of any civilized democratic polity. Our constitutional scheme is based upon the concept of rule of law which we have adopted and given to ourselves. Everyone, whether individually or collectively, is unmistakably under the supremacy of law. Whosoever the person may be, however high he or she is, no one is above the law notwithstanding how powerful and how rich he or she may be. For achieving the establishment of the rule of law, the Constitution has assigned the special task to the judiciary in the country. It is only through the courts that the rule of law unfolds its contents and establishes its concept. For the judiciary to perform its duties and functions effectively and true to the spirit with which it is sacredly entrusted, the dignity and authority of courts have to be respected and protected at all costs and at all times. 7. Rule of law controls the actions of the executive. The SC emphasized the importance of the rule of law in the context of Indian Constitution in State of Bihar vs. Rani Sonabati Kumari, Air 1961 SC 221 by observing that, it is of the essence of the rule of law that every authority within the state including the executive government should consider itself bound by and obey the law. When the state government obeys the law or gives effect to an order of the court passed against it, it is not doing anything which detracts from its dignity, but rather invests the law and the courts with the dignity which are their due, which enhances the prestige of the executive government itself, in a democratic setup. In State of MPV. Bharat Singh, Air 1967 SC 1170, the MP. Public Security Act, 1959 invested the district magistrate or the state government with wide discretion without procedural safeguards to expel any person from any specified area if his activities were found prejudicial to the maintenance of public order or security of the state. The provision was held unconstitutional because of unfettered discretion conferred upon officials and strict application of Dicey's rule of law doctrine. In D.C., Wadhwa vs. State of Bihar, Air 1987 SC 579, the constitutional question before the SC was whether governor under Article 213 had the power to repromulgate ordinances from time to time without getting them replaced by acts of the legislature. The court applied the rule of law test to invalidate the act of repromulgation of ordinances by the governor. The SC observed, "The rule of law constitutes the core of our constitution and it is the essence of the rule of law that the exercise of the power by the state, whether it be the legislative or the executive or any other authority, should be within the constitutional limitations and if any practice is adopted by the executive which is in flagrant and systematic violation of its constitutional limitations, a member of the public would have sufficient right to challenge such practice by filing a writ petition and it would be constitutional duty of the SC to entertain the writ petition and adjudicate upon the validity of such practice." Conclusion. Various constitutional provisions make it clear that the concept of rule of law in India is duly recognized by the Constitution of India. And it is further strengthened, expanded and firmly established by the judicial pronouncements. The draconian concept of law has its departure quite some time back and rule of law is the order of the day. The SC in its numerous judgments clearly indicate that the principle of rule of law is part of the basic structure of the constitution and therefore, it cannot be abrogated or destroyed even by parliament. It is also regarded as a part of natural justice. The SC in M. Nagraj vs. UOI, Air 2007 SC 71 observed, equality, rule of law, judicial review and separation of powers are distinct concepts. They have to be treated separately, though they are intimately connected. There can be no rule of law if there is no equality before the law. And the rule of law and the equality before the law would be empty words if their violation was not a matter of judicial scrutiny or judicial review and judicial relief, and all these features would lose their significance if judicial, executive and legislative functions are united in only one authority, whose dictates have the force of law. The SC in National Legal Services Authority vs. UOI, 2014-5, S.C. C. 438 observed, rule of law is an important pillar of the Indian Constitution and aims to fulfill the goals of social justice through public order. It is the rule of proper law, which balances the needs of society and the individual. The rule of law strikes a balance between society's need for political independence, social equality, economic development and internal order on the one hand, and the needs of the individual, his personal liberty and his human dignity on the other. It is the duty of the court to protect this rich concept of the rule of law. In recent times, the Supreme Court has evolved a whole lot of human rights jurisprudence by giving a liberal and dynamic interpretation to Article 14, right to equality, Article 19, right to freedoms, and Article 21, right to life and personal liberty, of the Constitution. Thus, various implied fundamental rights, like right to dignity, right to livelihood, right to clean environment, right to information, right to free legal aid, right to speedy trial, right to freedom from torture in police custody or jails, right to minimum wages, right to compensation for unlawful detention has emerged. Further, under public interest litigation, anyone having sufficient interest in the subject matter of the dispute, even though he himself is not an aggrieved party, may approach the court. These measures have greatly strengthened the rule of law by protecting the rights and ensuring the dignity of the individual. Judicial activism as valiant exercise is seen as a part of the efforts of the courts in India to establish rule of law society. In conclusion, we may say that by and large the Indian legal system provides all the machinery necessary for the development and maintenance of the rule of law. Leading case laws. State of Madhya Pradesh vs. Bharat Singh. Air 1967 SC 1170. Facts. Section 3 of the MP. Public Security Act, 1959 powered the state government or the district magistrate to extern a person from any place in the state and to intern him in any specified place in the state if that person is acting or is likely to act in a manner prejudicial to the security of the state or to the maintenance of public order. In exercise of this power, the state passed an order in April 1963 while national emergency was in force during the Indochina War, directing the respondent, I, that he shall not be in any place in the Raipur district. E, that he shall reside in the municipal limits of Jhabua town, district Jhabua, MP, and shall proceed there, immediately on the receipt of this order. And E, that he shall notify his movements and report himself personally every day 8 am and 8 pm to the police station officer, Jhabua. Thereafter, the respondent moved a petition in the MP High Court under Articles 226 and 227 challenging the order on the grounds, inter alia, that Section 3 of the Act which authorized imposition of restrictions on movements, actions of persons were ultra vires in that they infringed the fundamental freedoms guaranteed under Article 19, 1d, and a, and that the order was discriminatory, illegal and violated principles of natural justice. The High Court declared certain clauses of Section 3 as invalid because they contravened the fundamental freedom of movement guaranteed under Article 19 and therefore the directions contained in clauses E and E of the impugned order were invalid. The state has appealed to the SC against the order. State submissions. 1. So long as the state of emergency declared on October 20, 1962, by the President under Article 352 was not withdrawn or revoked, the respondent could not move the High Court by a petition under Article 226 on the plea that by the impugned order his fundamental right guaranteed under Article 19, 1d, was infringed. 2. If Section 3, 1b, was, because it infringed the fundamental freedom of citizens, void before the proclamation of emergency, Article 358 protects action both legislative and executive taken after proclamation of emergency and therefore any executive action taken by an officer of the state or by the state will not be liable to be challenged on the ground that it infringes the fundamental freedoms under Article 19. Legal issues. Whether the state or its officers may in exercise of executive authority infringe the rights of the citizens merely because the legislature of the state has the power to legislate in regard to the subject on which the executive order is issued. Whether Article 358 confers immunity from the process of the court to an executive action which operates to the prejudice of any person without any support of some legislative authority. Whether the order made by the state in exercise of the authority conferred by Section 3 of the MP. Public Security Act, 1959 was valid. Supreme Court's observations, Justice Shah. 1. The impugned act was brought into force before the declaration of the emergency by the President. If the power conferred by Section 3, 1b, authorized the imposition of unreasonable restrictions, the clause must be deemed to be void, for Article 13, 2, prohibits the state from making any law which takes away or abridges the rights conferred by Part 3, and laws made in contravention of Article 13, 2, are to the extent of the contravention void. Section 3, 1b, was therefore void when enacted and was not revived when the proclamation of emergency was made by the President. 2. Article 358, which suspends the provisions of Article 19 during an emergency declared by the President under Article 352, is in terms prospective, i.e., after the proclamation of emergency. Nothing in Article 19 restricts the power of the state to make laws or to take any executive action which the state, but for the provisions contained in Part 3, was competent to make or take. Article 358, however, does not operate to validate a legislative provision which was invalid because of the constitutional inhibition before the proclamation of emergency. 3. All executive action which operates to the prejudice of any person must have the authority of law to support it, and the terms of Article 358 do not detract from that rule. Article 358 expressly authorizes the state to take legislative or executive action provided such action was competent for the state to make or take, but for the provisions contained in Part 3 of the Constitution. Article 358 does not purport to invest the state with arbitrary authority to take action to the prejudice of citizens and others. It merely provides that so long as the proclamation of emergency subsists, laws may be enacted, and executive action may be taken in pursuance of lawful authority, which, if the provision of Article 19 were operative, would have been invalid. 4. Our federal structure is founded on certain fundamental principles. The sovereignty of the people with limited government authority, i.e., the government must be conducted in accordance with the will of the majority of the people. The people govern themselves through their representatives, whereas the official agencies of the executive government possess only such powers as have been conferred upon them by the people. B. There is distribution of powers between the three organs of the state: legislative, executive, and judicial, each organ having some check, direct or indirect, on the other. And C. The rule of law, which includes judicial review of arbitrary executive actions. 5. As pointed out by Dicey in his introduction to the study of the law of the Constitution, the expression, rule of law, has three meanings, or may be regarded from three different points of view. It means, in the first place, the absolute supremacy or predominance of regular law is opposed to the influence of arbitrary power, and excludes the existence of arbitrariness, of prerogative, or even of wide discretionary authority on the part of the government. 6. Dicey points out, in almost every continental community, the executive exercises far wider discretionary authority in the matter of arrest, of temporary imprisonment, of expulsion from its territory, and the like, than is either legally claimed or in fact exerted by the government in England. And a study of European politics now and again reminds English readers that wherever there is discretion there is room for arbitrariness, and that in a republic no less than under a monarchy discretionary authority on the part of the government must mean insecurity for legal freedom on the part of its subject. 7. We have adopted under our constitution not the continental system but the British system, under which the rule of law prevails. Every act done by the government or by its officers must, if it is to operate to the prejudice of any person, be supported by some legislative authority. 8. The state relied on Article 162 and on the decision of the SC in the Ram Javers case, AIR 1955 SC 549, wherein the SC observed, the language of Article 162 clearly indicates that the powers of the state executive do extend to matters upon which the state legislature is competent to legislate, and are not confined to matters over which legislation has been passed already. These observations must be read in the light of the facts of that case. The executive action which was upheld in that case is not supported by legislation, but it did not operate to the prejudice of any citizen. In that case, the state had done no act which infringed a right of any citizen. The state had merely entered upon a trading venture. Viewed in the light of facts of that case, the observations relied upon do not support the contention that the state or its officers may in exercise of executive authority infringe the rights of the citizens merely because the legislature of the state has the power to legislate in regard to the subject on which the executive order is issued. Decision. Section 3(1)(b) of the Act authorized the state to order a person to reside in the place where he is ordinarily residing, and also to require him to go to any other area or place within the state and stay in that area or place. If the person fails to carry out the direction, he may be removed to the area or place designated and may also be punished with imprisonment, fine. This act does not give any opportunity to the person concerned of being heard before the place where he is to reside or remain in is selected. The place selected may be one in which the person concerned may have no residential accommodation, and no means of subsistence. The Act nowhere provides that the person directed to be removed shall be provided with residence, maintenance, or means of livelihood in the place selected. In the circumstances, we agree with the High Court that Section 3(1)(b) authorized the imposition of unreasonable restrictions insofar as it required any person to reside or remain in such places may be specified in the order. It must be struck down in its entirety as unreasonable. The order made by the state in the exercise of the authority conferred by Section 3(1)(b) of the MP. Public Security Act, 1959 was invalid, and for the acts done to the prejudice of the respondent after the declaration of emergency under Article 352, no immunity from the process of the court could be claimed under Article 358, since the order was not supported by any valid legislation. The appeal, accordingly, is dismissed.